Hello, and welcome to Canadian Rights Reviews, where we examine the ins and outs of Canadian rights, freedoms, laws, and policies. Today I want to talk about police powers to arrest without a warrant. There is no accompanying video for today. This is a technical area of the law that I feel requires single focus. It is also a very important part of the law, in regards to individual rights and freedoms. In my opinion, the powers of police to arrest without warrant is not understood by most of the general public, many in law enforcement, and surprisingly even a fair amount of judges. Most of you probably think if you commit a crime you can be arrested by police warrant or not. That is not the case. To understand the finer points involved, we must start with a base level of understanding of the legal system in Canada and the types of offences. For many that may watch a lot of crime movies, TV shows, auditing or cop watch videos, the majority of this content comes from the United States. You will likely be more familiar with American legal terms than Canadian ones. For a number of reasons, America has a very complex legal system. In Canada, for better or worse, our system is much more simple. Canada's legal system uses a simple and straightforward top-down system. Our top tier is all of our federal legislation, which includes our Charter of Rights and Freedoms, Criminal Code, Human Rights Act, Motor Vehicle Safety Act, and so on. The next tier down is our provincial and territory legislation. These include Provincial Highway or Motor Safety Acts, Provincial Offences Acts, and so on. In fact, each province and territory generally has their own legislation for many areas already covered federally. Then we move down to lower tiers to include bylaws for cities, municipalities, towns, and so on. Quebec uses a different legal system for civil or private matters but otherwise use the same public and criminal law systems as the rest of the country. Here is the important part to know. The second and lower tiers must work within the constraints of the higher tiers. This allows us to easily understand, for example, that human rights within Canada are the same everywhere in the country. Despite having provincial and territory acts and codes, they must all work within the framework of the Federal Human Rights Act. As the Federal Act clearly defines what are prohibited grounds for discrimination, that cannot be limited by a lower tier of legislation. The Federal Criminal Code is another good example of the simplicity of our legal system. All of the more serious crimes you can be charged with in Canada are in the Federal Criminal Code. While there are provincial offences and city bylaws, these are all minor or summary offences, more on that later. The Criminal Code working in this way also makes case law from one province applicable to others. We don't have to determine which circuit of appeal to check case law from, as in America. In Canada we have indictable, summary, and hybrid offences. Indictable are our more serious crimes. Summary are considered lesser or minor offenses. Hybrid are offenses that can be charged as indictable or summary, dependent on the specifics of the case. On June 11, 2019, Bill C-75 received royal assent. Numerous changes were included, but for the purpose of this video we want to focus on the reclassification of offenses that took effect September 19, 2021. Many offenses that were previously indictable were reclassified as hybrid. This allows them to be tried as summary offenses, in what are considered minor violations, of what can be considered a much more serious crime. To balance that change, the maximum penalties for summary offenses were increased across the board, as was the statute of limitations for summary offenses. A word of caution if you find yourself needing a lawyer. Even though it has been more than 18 months since these changes have taken effect. In researching for this video, I found many law firms' websites still presenting the law as it was before this change. Personally, if a law firm cannot keep up with, and represent to the public, what the actual current laws are, I would keep looking if you come across one of these firms. Let's examine what you can expect if charged with each of these three types of offenses. For indictable offenses, there is no statute of limitations in Canada. We also do not have the death penalty. If being prosecuted for an indictable offense, in most cases you get the choice of a bench or jury trial, and you will have a preliminary hearing. In almost all cases you will be subject to fingerprinting and photos. If convicted, where you serve your time is dependent on the duration of your sentence. Police have the power to arrest without warrant for indictable offenses with few exceptions, which we will examine later. Summary offenses have a 12-month statute of limitations. You do not have the option of having a jury trial. You are not subject to fingerprinting and photos, and do not get a preliminary hearing. If you prefer, your lawyer can represent you in court, you only have to attend if so ordered by the judge. All provincial offenses are summary offenses. Many provinces still reflect the lower statute of limitations and penalties for these offenses. I would expect that to change in the future. In most cases, the police cannot arrest you without a warrant for this type of offense. We will get into the specifics later, but this is the main focus of this video, because police unlawfully arrest for these type of offenses all the time. Hybrid offenses can be charged as indictable or summary based on which way the Crown elects to proceed. The maximum penalty is determined by that election. There are times a Crown may decide to prosecute and is forced to elect to proceed as an indictable offense because more than 12 months has passed. If the Crown and defense agree, these can proceed as a summary offense, even though outside the statute of limitation. Again, except in limited circumstances, the police do not have the power to arrest without warrant for these types of offenses. Important note, this video is in regard to police powers. In cases of citizens' arrest, the powers are actually more broad. Section 495 of the Criminal Code covers police powers of arrest without a warrant. It appears pretty straightforward. Police can arrest without warrant anyone that has or they believe is about to commit an indictable offense, anyone they find committing a crime, and anyone with outstanding warrants in the province or territory they are in. The problem is, this is only Part 1 of Section 495. Part 2 provides limitations which many are not aware of, ignore, or read as being separate from Part 1. You can go and find on any number of websites right now, including the Department of Justice, statements that if you are found committing a summary or hybrid offense, you can be arrested. There is even some case law that interprets the law in that manner. This is not the case, as we will show through further examination in case law. Part 2A through C state when you cannot be arrested by police without a warrant. Those are detailed as any indictable offenses in Section 553, and all hybrid and summary offenses. The limitations when police can arrest without warrant apply to Part 2A through C, in all cases. Being found committing a crime does not exclude these limitations except in cases as detailed in D&E. Those cases are when there is need to establish identity, to secure or preserve evidence, or to prevent the continuation or repetition of the offense, or another offense. If these three needs can be reasonably satisfied without an arrest, and the police do not have reasonable grounds to conclude the suspect is a flight risk, with regard to court appearances, then there should be no arrest. Some have, and will point to the language of, that in the public interest, having regard to all the circumstances including the need to. For clarification, I will turn to the 1995 case of R. v. Fasanov. This case specifically challenged the broad public interest language. Mr. Fasanov lost his case, as the judge ruled the police arrested him to prevent repetition of the crime. However, the judge went on to state, I therefore conclude that the subsection may be severed, or more appropriately, read down so as to preserve the right to arrest without warrant, in the specific circumstances referred to above. In the result, there will be a declaration that Section 495 2d is invalid to the extent that it permits an arrest without warrant for the offenses mentioned therein solely on the grounds of the public interest, but that it is valid to the extent that it permits the arrest in the public interest, limited to the needs to establish identity, secure evidence, and prevent the continuation or repetition of the offense, or the commission of another offense. Understanding this language, it becomes easy to recognize that if you are caught committing an offense, there may need to be an arrest to prevent the continuation or repetition of the offense, but there must be a consideration by the police, if that need can be reasonably met without an arrest. If there is no consideration given to the limitation, or it is found the need could have been otherwise reasonably met, then the arrest is unlawful. I am going to use Canadian Rights Media's arrest for stunting as an example, as it is the best available in reviews I have completed to illustrate this point. CRM provided ID, there was no evidence to secure, as there has been no attempt to obtain CRM's video footage. All we are left with is the need to prevent the continuation or repetition of the offense. The officers referred to complaints of CRM approaching and stopping pedestrians and vehicles in relation to stunting. That reference clearly shows they do not believe standing on the side of the road with a camera alone constitutes stunting. That said, they were not arresting to stop the offense, as they did not find him committing the offense. Is it then reasonable to arrest CRM to prevent repetition of stunting, a summary offense? To answer that question, let me ask another question. Is it reasonable to arrest someone for speeding to stop them from speeding again? Sure isn't. You give them a ticket, tell them to slow down, end of interaction. I do not feel the officers involved in CRM's case even consider the limitations to the power of arrest without warrant, that alone makes the arrest unlawful if proven. If they did consider it, clearly the need to prevent repetition of the offense could have otherwise been reasonably achieved. That all said, regardless of guilt or innocence on the stunting charge, CRM's arrest was likely unlawful, and a breach of his charter rights. Section 495 also has a third part, which would now come into play. To paraphrase, this basically says if an officer is doing something they are not supposed to do, then they are acting lawfully, unless it is proven in court that they were acting unlawfully. The intention of this is to put burden of proof on the defense, to prove any claims of acting unlawfully. The police do not have to prove they were acting lawfully, they become the accused for the purposes of any such allegations. Sections 497 and 498 go on to cover the need for police to release those arrested without warrant as soon as possible, unless there is need to further detain the individual, with the same language and conditions as already covered in 495. For indictable offenses in Section 553, that police do not have the power to arrest without warrant, there is quite a bit included. Theft, fraud, possession of stolen property, and mischief clause D under $5,000 are all included. Charges related to gambling, betting, cheating, failure to comply with a probation order, and breach of recognizance, are other notable inclusions that you cannot be arrested for without warrant. Please check Section 553 of the Criminal Code for a complete list. Recently Film Canada Press was arrested for obstruction, for failing to ID in regards to a trespass offense. Without speaking on the validity of the trespass offense, if the police felt it was valid, they were entitled to arrest to obtain ID. However, FCP was not charged with obstruction, and was simply given a trespass summons prior to release. Why am I bringing this up? Police relocated FCP and released him several blocks away from the site of arrest. For the previously mentioned sections 497 and 498, police were required to release FCP as quickly as reasonable to do so. It can be argued, extending his detainment to transport him away from the site was unlawful and a charter violation. Understanding powers of police arrest without a warrant may or may not help you while such an arrest is occurring. Police generally are not going to listen to you with regards to what is legal or not. However, as these rules seem to be routinely violated, this knowledge can be very useful when defending yourself in court. There are numerous cases where arrests have been found to be unlawful, and evidence has been excluded, based on police failing to observe the limitations to the powers of arrest without a warrant. I have included links for a handful of these cases in the description. Thank you for watching, and we hope to see you again soon.